Welcome to the Art of Arbitration, where we explore the world of ADR. Today, I'm privileged to have Andrew Chin from the Hong Kong firm Gallant as my expert. Welcome. Thank you for coming.
And thank you for having me, Brett.
So before we begin to talk about arbitration in Hong Kong, why don't you tell me a little bit about yourself and how you got into this field?
Sure. I'm currently a litigation and arbitration partner at Gallant, which is a local Hong Kong law firm. I started my career in arbitration with Michael Huang Chambers in Singapore. Michael Huang is one of the preeminent Asian arbitrators. I then moved to Hong Kong around 2008 with my then girlfriend, now wife, who then obtained a training contract at an international firm. So since then, I started off doing construction litigation and arbitration, then slowly branching on to international commercial arbitration, which is what I practice today.
Okay, and so tell me what your current practice is and tell me a little bit about the firm.
Right. So perhaps I can just introduce something a bit more about myself to give a context about what I do.
Sure.
Given that I'm a Singaporean, we were brought up with a bilingual background. So I speak and write both English and Mandarin. And most of my work here deals largely with Hong Kong and PRC companies on cross-border disputes. Much of the legal work that I handle concerning arbitrations are generally seated in Hong Kong, or it could involve related litigation taking place in Hong Kong courts. So from time to time, I also help foreign companies, like those from the US or the UK, deal with the disputes involving PRC counterparties. And most of the time, the nature of the disputes I'm dealing with consists of a Sino-foreign business venture. And usually in those circumstances, they prefer to settle the disputes in Hong Kong. And this is because Hong Kong is common law jurisdiction with a good reputation for integrity and a well-rounded legal system. And this adheres to Western parties. And a lot of the times, Chinese counterparties are very comfortable with Hong Kong because it's home and seen as part of China. And apart from my work as arbitration counsel, also says arbitrator from time to time. So I'm on the list of arbitrators with the Hong Kong International Arbitration Center, Shanghai International Arbitration Center, and the BPI Arbitration Center.
So let's talk a little bit about the Hong Kong PRC arbitrations. So in order to have arbitration seated in Hong Kong, that would be pursuant to the initial agreement between the two parties, correct?
Yes.
And are PRC companies more willing now to arbitrate in Hong Kong than they were 25 years ago? Is it becoming a more common occurrence?
I think it has always been a common occurrence, simply because Hong Kong is so culturally similar to the mainland. So whenever foreign counterparties are involved and a common law regime needs to be adopted, most PRC counterparties just go to Hong Kong.
And because of that, if a U.S. company was doing a contract with a Chinese based company, it would be more likely that they would agree to have Hong Kong as the situs of the arbitration than other jurisdictions, right?
Yes, that's correct. Simply because Hong Kong is one of the preeminent hubs for international arbitration in Asia Pacific, and there are various reasons for this. First, I think most importantly is that Hong Kong, through mainland China, is a signatory to the New York Convention on the Recognition and Enforcement of Arbitral Awards. And this is an international convention that provides a benchmark for the recognition and enforcement of arbitral awards. It sets out very limited grounds by which arbitral awards can be set aside. So generally, parties tend to want to arbitrate in a state which is a signatory to the New York Convention. And the grounds for setting aside or refusing enforcement of an award are extremely limited. For example, the award is contrary to public policy, the subject matter is not arbitrable, or the losing party did not have a reasonable opportunity to present the case. So these are very limited exceptions. And the New York Convention has a very broad scope. It covers 172 signatory states around the world and involves very mature business jurisdictions like the US, the UK, France, Germany, BVI, Cayman Islands, Australia, Singapore. So it's a very well-organized system of enforcing arbitral awards. And another feather to its Hong Kong's cap is that it's adopted the Untitled model law with the 2006 amendments as part of its arbitration legislation. So as you may be aware, the Untitled model law is this framework set of laws which were devised by the United Nations Trade Commission in order to promote the use of arbitration in its member states. So it is generally seen by the arbitration community as a gold standard for any country which wishes to promote itself as a pro-arbitration jurisdiction. And third,
I'm sorry, go ahead.
Yeah, and third, and very importantly, is that in order to have a good arbitration hub, the legislation has to be in place, but also the supporting software has to be in place as well. So in terms of software, we usually think of the Hong Kong industry, and they are extremely pro-arbitration. So as you can see from the recent judgments, there have been very, very few cases where the award has been set aside or refused also. So the de facto, or rather the default outcome when it comes to a Hong Kong arbitration agreement or an award that challenges court is that it will be enforced.
So I have found that in the jurisdictions where a lot of the arbitrations take place, one of the reasons is they make it easy for the parties and the lawyers to arbitrate in that country. The lawyers can come in and practice. There's sophisticated systems in place. There's places to stay close to, they have the infrastructure to do that. Is that true in Hong Kong as well? I assume it is.
Oh, yes, of course. And in order to do a Hong Kong seated arbitration, you don't even have to be a registered lawyer. You can be anyone. As long as there's someone who's willing to appoint you as their legal representative, you can act in the Hong Kong arbitration. And if you want to say as an arbitrator in a Hong Kong seated arbitration, likewise, there are no restrictions as well. You don't have to be a registered lawyer. And there are also very favorable visa arrangements when it comes to arbitrations. Like, for example, if you're acting in arbitration, you can usually get expedited visa approval.
So you also said that the judiciary was pro-arbitration. Talk to me a little bit about if an issue involving arbitration is in a court, how that's assigned, how you have a specialty court, and then what can happen to a party who challenges the right to go to arbitration if they lose and the court says you have to arbitrate.
Yes, so all arbitration matters are filtered to a specialist list. And this specialist list is monitored by a specialist judge. The current specialist judge in charge of the construction and arbitration list is Madam Justice Min Chan, who is shown by her numerous judgments over the years that she is extremely pro-arbitration. And one unique feature of Hong Kong arbitrations when it comes before the Hong Kong courts is the penalty of indemnity costs for the losing party. And this is not seen in any jurisdiction around the world. As you may be aware, when a party loses a case, they have to pay costs to the winning party. And costs are usually assessed on two bases. One is a standard basis, where one would typically expect to get 60 to 70% of recovery of its legal costs spent in the legal proceedings. Whereas when it comes to indemnity costs, it's usually a much higher base, which is around 80 to 90% or even 100%. So there is a cost disincentive if you were to try to challenge an arbitral award in the Hong Kong court, as opposed to just any normal court proceedings or breach of contract where you have a losing party. The default order in those cases is that the losing party just pays costs on standard basis. And it's only in the very rare circumstances where there's been abuse of process that indemnity costs are imposed. So the default is that the judiciary considers that when you challenge an arbitral award and you lose, it's tantamount to an abuse of process.
And if you challenge the arbitration provision at the beginning of the matter in court, do you have the same potential indemnity costs? You're not challenging the award, you're saying this arbitration provision in the contract doesn't apply for some reason. If you lose that, do you also face the risk of indemnity costs?
Yes, you do.
So I would say it's far more likely that people go directly to arbitration and don't fight it because of the potential risks they have up front.
Yes, that's the current attitude in judiciary, which they are trying to impart to all practitioners in court.
So in Hong Kong, though, if there is a dispute about whether something is arbitrable, is that decided by a court or is that decided by the appointed arbitrators?
That would depend on whether it's being classified as an issue going to jurisdiction or whether it's an issue going to the arbitrability of the matter. So one has to keep these two concepts distinct in their minds. Jurisdiction simply means whether the tribunal has the power to adjudicate the claim. For example, if a tribunal was not constituted in accordance with the agreed procedure, or the arbitration clause is regarded as pathological, such that there is no clear intent on whether the parties intended to arbitrate, then that would be classified as an issue going to the jurisdiction of the tribunal. Arbitrability simply means whether the subject matter is capable of being arbitrated. For example, whether condition precedents to an arbitration have been satisfied. For example, as you may be aware, a lot of arbitration clauses nowadays are multi-tiered provisions, whereby they first provide for the parties' negotiations, followed by mediation, then as a measure of last resort, arbitration. So if you do not go through the preceding stages and you directly go to arbitration, that's a matter that's regarded as going to the arbitrability of the matter. And that when something goes to arbitrability, it simply means that it will be decided by the arbitral tribunal.
Okay, so let's talk a little bit about the tribunals in Hong Kong. Tell me a little bit about the institutions that are in Hong Kong that run arbitrations.
So, as you're aware, Hong Kong is a very major hub for arbitrations in the Asia Pacific, so it tends to attract a lot of major players. When people talk about Hong Kong, the first one that usually comes to mind would be the Hong Kong International Arbitration Center. It's listed in the most recent Queen Mary International Arbitration Survey as one of the top 3 arbitral centers in the world. And most of my arbitrations that I deal with are listed by the Hong Kong International Arbitration Center. However, there are other arbitration centers who have set up shop here. For example, the International Chambers of Commerce Court of Arbitration, ICC, the Shanghai International Arbitration Center, the Shenzhen Court of International Arbitration, and the Hong Kong branch of CTEC. CTEC stands for China International Economic and Trade Arbitration Commission, and that is a flagship arbitral institute in China.
So generally, and I know it's probably contract dependent, but generally, how are arbitrators chosen if you have a HKIAC arbitration?
Typically, if it's a sole member tribunal, from my experience, most of the time, the two parties cannot agree amongst themselves who should be the arbitrator. Hence, it tends to be the case that the sole arbitrator will be decided by neutral, whether it's by the arbitral institute or by the court. Whereas when it comes to a three-member tribunal, the default in the arbitration ordinance is that each party will get to choose their own arbitrator, with the third arbitrator being appointed by the two-party non-native arbitrators.
And is it the case, as I've heard in a lot of the advanced arbitration jurisdictions, that the arbitration list is generally small, so you're seeing the same people often, they are appointing each other often. It's a it's a group that's diversifying but is not large. Is that true in Hong Kong as well?
I think if you talk about Hong Kong practitioners, by the very fact that Hong Kong is not a very big place, it's only as a population of 7 million. So one would naturally expect that any niche community, be it arbitration or whether it's the medical community specializing in ophthalmology, you expect it to be small compared to what you usually see in the UK or even in the United States. So and so it's just a function of that tend to see the same people over and over again. But that doesn't mean that new entrants find it difficult to come in. I think that as long as someone can establish himself or herself as a credible arbitration practitioner, I see no reason why that person would not be appointed as an arbitrator.
Do you need to be a Hong Kong lawyer to be or a Hong Kong resident to be an arbitrator in the HKIAC?
Not at all. Not at all. In fact, you don't even need to be a lawyer to be an arbitrator. You can be anyone. As long as someone nominates you and that nomination does not offend any provision of the arbitral rules, then you can be the arbitrator.
And I understand that you sometimes serve as an arbitrator. What institutions do you arbitrate for?
Usually I arbitrate with the HKIAC, the Hong Kong International Arbitration Center, simply because by virtue of the fact that they have the most number of arbitrations within.
So if you could tell us, when you sit on that side of the argument and you're the decision maker, you're the arbitrator, what has been the one thing you've learned that you would tell lawyers who are practicing in arbitration to either do or not to do? What one thing surprised you as an arbitrator?
I think the one thing that I would advise practitioners or their legal representatives or parties' legal representatives is simply to be concise and straight to the point. Because arbitrators are only concerned with one thing, and that's deciding the case in the manner which they feel to be fair. And as long as you can give the arbitrator the comfort that they are doing the right thing, then you will be seen as a more persuasive representative.
So let me backtrack for a second, and I want to get back to that. Tell me about the role of the Hong Kong court during an arbitration. For example, I understand from our prior conversations that if you want any information from a third party, individual or company, in the arbitration, you have to go to court to get a subpoena for them to either give you documents or to testify. Is that correct?
Yes, that's correct. So non-parties are not subject to the jurisdiction of the arbitral tribunal. And if you do want evidence from non-parties, whether by way of documents or you want someone to testify in the arbitration, and that person is unwilling to produce a document or appear before the tribunal, then you actually have to go to court to get a court order for that.
So that seems to be the rule in a lot of jurisdictions. Just interestingly, um, if a arbitration is covered by the Federal Arbitration Act in the United States, the Federal Arbitration Act gives the arbitrators the authority to issue subpoenas that can then be enforced in court if you need to. It's a little bit different system and makes it a little bit easier to arbitrate here because you don't necessarily have to go through the court. It's just it's a small advantage that I've noticed through my discussions with others. So turning back to your advice to lawyers who are arbitrating, um, talk to me a little bit about the use of witness statements in arbitrations, which again is something we don't generally do. An arbitrator can allow it, but we don't generally do, even though it's standard in most of the world. But talk to me about how witness statements can be and are used in arbitrations in Hong Kong.
Right. So, as you may be aware, in the common law trial procedure, our witness statements play a very important role in that they stand in place of the evidence in chief of the witnesses. Like for in the US, I know that you do depositions, but in Hong Kong and in many other common law jurisdictions like Singapore or even the UK, um, the first round of evidence from a witness as to his or her factual recollections about the case is given by way of a witness statement. So what it usually means in practice is that the witness sits down with a lawyer, the lawyer interviews the witness, produces a witness statement, and once you have that witness statement and it comes to hearing, then you can proceed directly to cross-examination, whereby the opposing counsel will simply ask you questions to try to undermine the witness's credibility. So you save a lot of time in that regard in hearing. By contrast, if you don't have witness statements, for example, in criminal proceedings here, you don't have witness statements. What you have to do is that when the witness takes a stand, you haven't heard anything from the witness prior to the witness taking a stand. So the party who's calling the witness, that party's counsel will have to ask questions to elicit evidence in support of his or her client's case. So that just takes up a huge chunk of time during the hearing that could otherwise be saved if witness statements were used.
So you spoke a little bit about evidence and witness statements as evidence. Are there any specific rules of evidence that apply in a general Hong Kong arbitration? Are there set rules that the tribunals have, or is that something that is decided by the arbitrator or arbitrators?
The general rule is that the arbitrators are masters of procedure and evidence. So it will be up to the arbitrators to determine the admissibility, relevance, and weight of any particular piece of evidence. And it is expressly disapplied by statute, the rules of evidence in court. So the rules of evidence in court don't apply to arbitrations. But in practice, of course, the arbitrators cannot operate in a vacuum when it comes to determining issues of evidence. So what happens in practice is that they usually refer to the IBA rules on taking of evidence in international commercial arbitrations. IBA stands for International Bar Association. So the IBA rules, if I can just abbreviate it as such, is a set of rules formulated by the IBA following deliberations by a committee that comprises of both civil law practitioners and common law practitioners. So it is a melting pot of the best legal traditions from both civil law and common law, and which is why it has attained status that it has today in international arbitrations, not just in Hong Kong, but elsewhere around the world. And for myself, I haven't come across an arbitration that does not refer to the IBA on evidence.
So that's evidence. How about the issue of discovery? If I want documents from the other party in a Hong Kong arbitration, is there automatic disclosures? We have that in some of our arbitration tribunals here. Or is there a procedure that you need to go through to get documents?
There is no automatic discovery in Hong Kong arbitrations, like court proceedings. In court proceedings, you have to disclose all documents that are relevant to a case or documents which could lead to a train of inquiry as to relevant documents to be disclosed. That you have to do for Hong Kong court proceedings, and you also have to swear that your disclosure has been complete and all the copies that you have disclosed are authentic. Whereas in arbitration, there's no automatic discovery. And if you want any document from the inside, you would have to make an application as such. And the application is normally made by way of a Redfern schedule. A Redfern schedule is named after Professor Alan Redfern, who was a very common UK arbitration lawyer. And he came up with this procedure where if you want to apply for a particular document, you will have to put in your request in table format. The first column would be the document which you are requesting. The second column is that why you think is relevant. Third column, why you think is material. The fourth column is the other side's objections or counter proposal as to discovery. And the fifth column would be the tribunal's findings.
So you have to clearly meet with the other side before you send the Redfern schedule into the tribunal?
Yes, that's correct. So usually Redfern schedules are first exchanged beforehand. And then it is only in circumstances where the parties are disagreed on whether a document should be produced that goes to tribunal for determination.
So in effect, though there is no automatic discovery or document disclose, exchange, if I am in a case against you and I send you over a draft Redfern schedule and you agree that all the documents are relevant, you just give them to me. It's not an issue that the arbitrators don't have to order the documents to be produced.
Yes, if I agree with all your requests, and
I'm very reasonable.
Yeah, and if that's the case, then why not? I mean, it helps saves cost for the clients, and I think that a lot of arbitrators expect both parties' representatives to come together and come up with a reasonable stance of disclosure for each document that's requested.
Is there an advantage to arbitration in Hong Kong due to their confidentiality as opposed to a court proceeding?
Is there an advantage? I would suppose you can say that some parties would choose arbitration simply because it's confidential. For example, if there's a dispute between a law firm and a client, there's something that you don't want the public to know about, and these matters usually go to arbitration. There are other industries that tend to be very pro-arbitration. For example, the construction industry. Almost all standard contracts provide for arbitration. For example, if you are a developer or contractor and you're responsible for a particular project, you definitely don't want the public to know that there's something wrong with that project. So they tend to go to arbitration. Likewise with the shipping and maritime community. Everything goes to arbitration.
So if a party goes to court to challenge the ruling of the arbitrators, does that remain confidential? Or is it simply public like all other court proceedings?
In Hong Kong, if there is an arbitration-related matter that goes before the court, it will be heard in camera. I think the term in camera simply means that it's heard in private. In typical court proceedings, the public is entitled to attend. And there is no way of restricting the public as to what cases it ought to attend. But in arbitrations, the public is not entitled to it. And even if the judge decides to publish a judgment on that particular arbitration matter, the names are anonymized. So you could have something like, for example, ABC versus EFG. So that if a member of the public reads a judgment, they wouldn't be able to work out who the parties are.
But they wouldn't be able to, for instance, here you could look at a docket and you could, which is publicly available, you could print it out and it would have the objection to the arbitrator's ruling. It would say X company arbitrated with Y company over this problem, and here's what the arbitrators ruled, and here's why we're challenging it. That in Hong Kong, that would not be available to the public to see.
That's correct, unless in very, very exceptional circumstances, and I can't think of what they may be. Yeah, so the default approach of the Hong Kong courts is that arbitration-related court proceedings are few.
Interesting. So are there any type of non-criminal matters that can't be arbitrated under Hong Kong law?
Non-criminal matters, for example, that would depend, but it's a very limited scope. For example, when it comes to employment disputes, there are some matters that only fall within the exclusive jurisdiction of the tribunal. For example, claim for payment of monies owed to employee pursuant to the minimum wage ordinance. Those would fall within the exclusive jurisdiction of the legal tribunal, and therefore not arbitrable. You could have civil claims arising from investigations or prosecutions for insider dealing by the Securities and Futures Commission. Those are not arbitrable. And likewise, investigations for anti-competitive conduct and related civil claims that arise therefrom. Those are likewise not arbitrable.
So if I'm an American company in a dispute with a Hong Kong company and I have an arbitration provision that calls for the HKIAC, I can't arbitrate an anti-competitive claim even if Hong Kong law wouldn't apply? Or is it only if Hong Kong law? I can have the tribunal being Hong Kong. Hong Kong law doesn't necessarily apply. So is the preclusion for arbitration only when Hong Kong law applies and Hong Kong law says that you can't arbitrate?
Well, that's a difficult question and very technical one as well. I mean, if the parties have nothing to do with Hong Kong, but they choose Hong Kong simply as a neutral jurisdiction for their arbitration, I really don't know the answer off the top of my head. And I don't think there's a point that has been litigated in Hong Kong.
Interesting.
But if you ask my gut feeling, if the case has nothing to do with Hong Kong, apart from the fact that the parties have simply chosen Hong Kong as the seat of arbitration, then I see no reason why it cannot be arbitrated here, if it could be arbitrated under the applicable law.
Okay. We always try to talk a little bit about the role of mediation in your jurisdiction, whether it's in court or arbitrations. Are mediations a tool that are used often by litigators in Hong Kong? And if so, how is it done in court, and how, if at all, is it done in arbitration?
Okay, let me just deal with it, deal with the question of mediation with respect to court proceedings first and arbitration. So in court proceedings, parties' representatives, that means the lawyers, are legally obliged to advise the client on the potential of mediation and to actively engage in at least one mediation attempt before the case is being heard in court. And if you unreasonably refuse to mediate, then you could be penalized with costs. That means you have to pay an additional amount of cost over and above what you would otherwise have to pay if you had participated in the mediation. Whereas in arbitration, if both parties go to arbitration, there's no obligation to mediate. You could go all the way through to the logical conclusion of an arbitration without having to mediate. But parties can choose to, and sometimes it's required by the dispute resolution clause to engage in mediation prior to engaging in arbitration. But if there's no such requirement, it's really up to the parties and their legal representatives whether to engage in mediation. And if parties do decide to engage in mediation, most of the time they just appoint the party neutral to serve as a mediator. They ask for stay of the proceed arbitration to facilitate the mediation. The mediation is successful, then the arbitration stops. If not, then the arbitration continues.
So the mediator is usually someone different than the arbitrator.
Usually it's someone different, but they can be one and the same as well. In China, it's very common for the mediator to be the same person as the arbitrator. In Hong Kong, it's a bit less common, but it is possible. The arbitration ordinance in Hong Kong provides for such a possibility. And if the arbitrator takes the role of a mediator and it receives confidential information in the course of the mediation that one party is not privy to, then if the mediation is unsuccessful, the arbitrator has to disclose all the confidential information he has received from both parties, so as to ensure a neutral playing field.
So the advantage then, or if I'm an advocate, a lawyer for one of the parties, I would then not want the arbitrator to be a mediator. I would like to keep that confidential information confidential. So I think the logical thing then is to not use your arbitrator as a mediator. Is that fair?
Yeah, I think that's a very fair point of view, and I think that's the point of view that's adopted by most practitioners here at Hong Kong as well.
Thank you, Andrew, for your time today. It's been very informative, and we leave knowing a lot more about the practice of ADR in Hong Kong than we did when we came in, and I appreciate your time. Thank you.
And thank you, Brett, for giving me the opportunity to do a presentation on behalf of Hong Kong.